In this video, we are going to discuss on the characteristics of fundamental rights. So, fundamental rights, first characteristics, they are not absolute. They have reasonable restriction. They have exception. These are decided by the courts. They strike a balance between the rights of individual liberty and societal control, societal norms, social norms, etc. There is no absolute freedom. There is some restricting. Similarly, there is a restriction on fundamental rights as well. Some of the fundamental rights are available only to the citizen of India. For example, Article 15, Article 16, that is public employment, Article 19, freedom of expression, 29 and 30, that is cultural and educational rights. They are available only Indian citizens, while rest of the rights to both citizen as well as aliens, except enemy aliens. What do you mean by enemy alien? If India war with any particular country, then the citizen of that particular country becomes enemy alien. Thirdly, it is a protective against states' arbitrary action or random action, illegal action or unauthorized action. It is not available in case of violation by private individuals. For example, when GTV lost the contract from BCCI, it asks that its fundamental rights has been violated, but BCCI is the private individual. That's why court could not issue on the remedy. Please read that case. There is no special constitutional remedy, but only ordinary legal remedy available in the case. Many of them are negative in nature, meaning can't do this, state can't do that, state can't discriminate, state can't do this, state can't exploit, you can't do untouchability, you can't have a title. Okay, that's prevent states or individual from doing the on act. That is, it places limitation on state unlimited power and makes them limited, while others are positive in nature. Positive includes like you have right to religion, you have right to education, right to life. Now there is a justiciable in nature. That is, in case in violation, people can go to courts. Courts will pass some writs, and in turns there are enforced. It's justiciable and enforceable in courts of law. Obviously, person can move directly to Supreme Court under particular case under Article 32. They are not permanent in nature. They can be amended. Okay. They are very much part of the Constitution and they are not the part of the basic structure of the Constitution, so they can be amended. They can be suspended during national emergency except Article 20 and 21. Now 6 rights of Article 19 suspendable under only and emergency declared on the ground of war or external aggression. That is external emergency. There is an external threat, then the 6 rights of Article 19 are suspended. But they are not suspended if it is internal emergency. That is on the ground of armed rebellion. So 20 and 21 and 19 articles suspended during external emergency, while 20 and 20 can be suspended during internal emergency. Now their articles are obviously limited by Article 31A, letters for acquisition of estates. There are some exceptions. Article 31B talks about 19th schedule. If it is under 19th schedule, it's behind the judicial review, but only after Keshavananda Bharati case. Article 31C says that in order to giving effect to directive principles of state policy, some laws can be accepted. Most of them are directly enforceable, that is self-executory, while some like 21A can be enforced on the basis of the law. Okay, for example, right to education has been made a law. Such law can be made only by the parliament. No, obviously armed forces, paramilitary forces, they cannot have all the fundamental rights. Otherwise, it will create anarchy. So some restrictions are completely unavailable. Also, it can be happen if parliament make such laws. Military rule, which under Article 34 If law and order completely break down and if army is asked to take over, so martial laws and military rule, if it is there, then fundamental rights are restricted. Till now, it is not have been applied and it is differences from national emergency.